Your rent just jumped 40% and you've got 7 days to decide if you're staying or leaving. Sound familiar? Florida tenants are getting blindsided right now because the rental laws changed faster than anyone expected. Between July 2024 and early 2025, the state passed new rules that flipped everything upside down. And here's what nobody's telling you. Some of these changes look like they're helping you on the surface, but when you dig into the fine print, they're setting traps that most renters are walking straight into without even knowing it. Your landlord has already talked to their property manager, their attorney, or their real estate group. They know exactly what these rules say. You need to know them too. This video breaks down exactly what changed, what it means for your wallet, and most importantly, what you can actually do about it before it's too late. Child, the 30-day notice rule that changed everything. Back in June 2024, if your landlord wanted to end your month-to-month rental, they only needed to give you 15 days notice. That's barely 2 weeks to find a new place, pack everything you own, coordinate a move, and come up with first month, last month, and a security deposit somewhere else. As of July 1st, 2024, Florida changed this under the Residential Landlord and Tenant Act. Now, landlords must give you 30 days written notice to end a month-to-month tenancy. And on the surface, that sounds like a win. The extra 2 weeks genuinely helps, especially in Florida's brutally tight rental market. You get more breathing room to search, more time to save money for moving costs, and more time to avoid making a desperate decision you'll regret. But here's the catch that most people completely miss. This 30-day rule only applies to month-to-month leases. If you signed a fixed-term lease, whether that's 6 months, a year, or 2 years, your landlord doesn't need to give you any notice at all when the lease ends. The lease simply expires on whatever date is written in your contract. No warning, no reminder. Just an end date that arrives whether you're ready or not. And landlords figured out that loophole almost immediately. Instead of keeping tenants on month-to-month agreements where they have to give proper notice, many landlords are now pushing everyone into fixed-term leases from the start. When that lease expires, they either dramatically increase the rent or choose not to renew at all. Either way, you're out. The law requires the notice to be in writing, and that matters more than most tenants realize. Text messages don't count. Verbal conversations in the hallway don't count. Your landlord needs to send proper written notice by mail, hand delivery, or email, but only if you specifically agreed to electronic notices somewhere in your lease document. Keep every single piece of paper your landlord has ever sent you, because that written documentation becomes your entire defense if they ever try to push you out without proper notice. And the 30-day rule cuts both directions. You also need to give your landlord 30 days written notice if you want to leave a month-to-month rental. You can't just decide on a Tuesday that you're leaving in 2 weeks anymore. If you give less notice than required, your landlord can legally charge you rent for those extra days and pull it straight out of your security deposit before you ever see a dime of it returned. Security deposits just got a lot more complicated. Florida changed the security deposit landscape in mid-2023, but the real impact started hitting renters hard in 2024 when leases began renewing under the new framework. Under Florida Statute 8341, landlords can now offer you a choice when you sign a new lease or renew an existing one. You can either pay a traditional refundable security deposit the way things have always worked, or you can pay a smaller, non-refundable monthly fee added to your rent payment instead. Traditional security deposits operate exactly the way they always have. You pay 1 or 2 months rent up front, your landlord holds it in a separate account, and when you move out, if the place is in good condition and you've paid everything you owe, you get most or all of that money back. Florida Statute 83.49 controls exactly how landlords handle those deposits. They have 15 days to return your full deposit if they're making no claims against it. If they want to keep any portion, they must send you written notice within 30 days explaining exactly what they're charging you for and in what amount. Now, here's the newer option that sounds appealing until you actually think it through. Instead of that large upfront payment, your landlord can offer to let you pay a smaller monthly fee added to your regular rent. If you're moving on a tight budget and can't pull together $2,000 or $3,000 up front, that offer feels like genuine relief. But that monthly fee is non-refundable. Every single dollar of it is gone the moment you pay it, no matter how perfectly you maintain the apartment, no matter how spotless you leave it when you move out. Run the actual numbers. If your rent is $1,500 a month and your landlord offers a $50 monthly fee instead of a traditional deposit, that sounds manageable in the moment. But over 1 year, you've paid $600 that you'll never see again. Over 2 years, that's $200 gone permanently. Over 3 years, you're looking at $1,800 just evaporated. Money that would have come back to you under a traditional deposit if you'd kept the apartment in good shape. The law does require landlords to tell you in writing that you have this choice and they cannot force you to take the monthly fee option. But many landlords push it hard because it's significantly more profitable for them over time. Some tenants never realize a choice exists at all. They just assume whatever the landlord presents is the only option on the table. If you do pay a traditional security deposit, Florida law limits what landlords can charge. As of 2025, the deposit collected before you move in cannot exceed 1 month's rent. Read your lease carefully. If you're planning to rent for just a few months, maybe the fee structure makes sense. But if you're settling in somewhere for 2 or 3 years, that monthly fee is quietly draining thousands of dollars that you're simply never getting back. Also worth knowing, if you choose the monthly fee option and your landlord uses that money to purchase some form of insurance protection for themselves, you are not covered by that insurance. You are still 100% liable for any damages that occur during your tenancy. Rent increases have no limits in Florida, and that's not changing. Florida does not have rent control. Let that sink in completely because it's the most important financial reality for every renter in this state. There are 0 statewide rent control laws in Florida. Your landlord can raise your rent by any amount they want, at any time they want, as long as they follow the applicable notice rules. Your rent is $2,000 this month. Your landlord can make it $2,800 next year. That's completely legal. A 100% increase is still legal. The only real limit is whatever the rental market will bear, and in Florida right now, the market is bearing a lot. This is fundamentally different from states like California or New York, where rent control exists in certain cities and provides at least some protection for long-term tenants. In Florida, state law actually bans local governments from creating their own rent control ordinances entirely. Miami-Dade tried, Tampa tried, Orange County tried. The state shut every single one of them down in July 2024 when over 40 local ordinances were invalidated in a single sweep. The only narrow exception is if there's a declared severe housing emergency, and even then, any rent control measure must be approved by public vote and can only last 12 months before it expires. As of early 2026, no Florida city or county has any active rent control in place. So how do landlords notify you about rent increases? For month-to-month leases, Florida state law doesn't set a specific minimum notice period. The law simply says landlords must give you reasonable notice, and most landlords interpret that as 15 to 30 days because that's what most courts consider fair. Miami-Dade County and Royal Palm Beach have both historically required 60 days written notice for rent increases above 5%, though whether those local rules remain enforceable after the state preemption of local ordinances is genuinely unclear right now. For fixed-term leases, like a standard 1-year agreement, your landlord cannot raise your rent in the middle of the lease period unless the lease itself specifically gives them that right in writing. But once that lease expires, all protections disappear. Your landlord can hit you with whatever increase they decide is appropriate, and you have to choose quickly, accept it, or start searching for a new place in a market where almost nothing is cheaper. Many landlords now send rent increase notices 60 days before a lease expires, knowing full well that most tenants in today's Florida market can't find anything comparable at a lower price. There's also no cap on frequency. For month-to-month tenants, a landlord could theoretically raise the rent every single month as long as they provide proper notice each time. Rent increases cannot legally be discriminatory or retaliatory. Your landlord can't raise your rent because of your race, religion, national origin, disability, or because you complained about necessary repairs. But proving discrimination or retaliation in court is extraordinarily difficult unless your landlord is careless enough to document it themselves. The anti-squatter law that's hurting legal tenants. On July 1st, 2024, Florida passed what most people are calling the anti-squatter law. The official intent was to let landlords deal quickly with people who break into vacant homes and occupy them without any authorization. The actual result has been something quite different and far more dangerous for legitimate paying tenants. Under this law, if your landlord claims they believe you're an unauthorized occupant, they can file a sworn affidavit directly with the sheriff's office. The sheriff can then remove you from the property without going through the normal eviction court process. The entire removal can happen within days, not weeks or months. Think about that for a moment. The normal eviction process exists specifically to give tenants due process, a chance to appear in court, present their evidence, and have a judge make an impartial decision. This law effectively bypasses that entire system when a landlord files an affidavit claiming unauthorized occupancy. And the problem is that the definition of unauthorized occupant is being stretched in ways the legislature probably didn't intend. Say your written lease expired 3 months ago, but you kept paying rent every month and your landlord kept accepting it. Under Florida law, you're almost certainly a month-to-month tenant at that point, with full legal rights. But your landlord could file an affidavit claiming you're an unauthorized occupant and use this process to remove you without a court hearing. You could come home on a random Wednesday to find your belongings on the lawn and the locks changed. Your legal protection under this law is supposed to be that you can show proof of tenancy, a signed lease, rent payment receipts, utility bills in your name, bank statements showing monthly payments going to your landlord. But if your landlord files that affidavit on a Friday afternoon and the sheriff acts quickly, you may not have any opportunity to present your evidence before you're removed from the property. The law does state that anyone who makes a false sworn statement can face perjury charges. But perjury charges are cold comfort when you're already standing on a sidewalk with your furniture. Getting back into a property after a wrongful removal requires attorneys, court filings, and potentially weeks or months of legal proceedings. The practical lesson for every renter in Florida is this: get everything in writing always. Keep multiple copies of your lease in different locations. One physical copy somewhere safe, one digital copy in cloud storage, one emailed to yourself. Keep every rent receipt. Keep every bank statement showing payments. Keep every text message related to your tenancy. If your landlord ever attempts to claim you have no right to be in that property, you need documentation you can put your hands on within 5 minutes. Local tenant protections got eliminated statewide. July 1st, 2024 was genuinely one of the worst days for Florida renters in recent memory. That's when state preemption went into full effect and wiped out over 40 local tenant protection ordinances that cities and counties across Florida had built over years. Cities and counties had watched the state fail to protect renters and had tried to fill the gap themselves with local rules. The state's response was to make those local rules illegal. Orange County had a tenant bill of rights with specific enforceable protections. Gone. Tampa had enhanced renter protections. Gone. Florida Statute 8344 now clearly states that local governments cannot regulate anything the state already addresses, and that list includes security deposits, lease applications, rental agreement terms, tenant and landlord rights and responsibilities, fees, and notice requirements. Before preemption, some cities required landlords to register every rental property with the city, creating accountability and an inspection record. Some cities required habitability inspections so tenants knew the property met basic standards before they signed. Some cities gave tenants extra time to respond to eviction notices, providing a meaningful cushion when people faced losing their homes. Every one of those protections is gone now. Orange County's Tenant Bill of Rights had specific, clear provisions about landlord retaliation with defined protections if you complained about needed repairs or reported code violations to the city. Those specific protections no longer apply. You're back to vaguer state law protections that are significantly harder to enforce in practice. The preemption law doesn't just eliminate existing ordinances, it permanently prevents cities and counties from passing new tenant protections in the future. So when local elected officials watch their constituents getting displaced by skyrocketing rents and want to do something about it, they legally cannot act. This hits hardest in the high-cost markets where renters are already under the most pressure. Miami, Fort Lauderdale, Tampa, Orlando. Exactly the places where rents have climbed fastest and where local officials had been most motivated to create additional protections. Email notices are now legal, but they come with hidden dangers. Starting July 1st, 2025, landlords and tenants can mutually agree to exchange legally required notices by email. This sounds like a straightforward convenience upgrade in an era when everyone communicates digitally. The reality is more complicated and potentially dangerous for tenants who don't understand exactly what they're agreeing to. If you and your landlord agree in writing, you can exchange notices via email instead of certified mail or physical hand delivery. This applies to everything important, yet eviction notices, rent increase notices, security deposit claims, lease termination notices, all of it. The agreement to use email must be documented in your written lease or in a separate addendum that both parties sign. Here's the detail that makes this genuinely risky. The law specifies that a notice sent to an agreed email address counts as legally delivered at the moment it is sent, not when you actually open it, not when you read it, not when you acknowledge it. If your landlord sends you an eviction notice at 3 in the morning and you don't check your email until noon the following day, the legal clock started ticking at 3 in the morning. You've already lost 9 hours of whatever response time you have. Consider what can go wrong in ordinary life. Your email account gets compromised and you lose access. Your inbox fills up and filters things automatically. Your landlord's domain ends up on your spam filter's block list. You switched email providers 6 months ago and forgot to update your landlord. Any of these completely ordinary situations could result in you missing a critical legal notice that the law considers fully delivered even though you never saw it. You could face eviction proceedings because an automated notice went to your spam folder. Be extremely cautious about agreeing to email notices. If you do agree, create a dedicated email account used exclusively for landlord communications. Check it every single day without exception. Set up push notifications on your phone and keep that inbox meticulously organized. And understand that you don't have to agree. Email notice is entirely optional and your landlord cannot force you to accept it. If you prefer certified mail where there's a physical delivery record that requires your signature, you can require that. Get your preference documented in writing when you sign your lease so there's no dispute about what was agreed later. Flood disclosure rules changed in October 2025. As of October 1st, 2025, Florida landlords are required to disclose flood risk information before you sign any lease. This new requirement emerged from growing concerns about climate-related flooding and the increasing frequency of major storm events across the state. Under the law, landlords must disclose the property's FEMA flood risk zone designation and any history of flooding that has occurred at the property. This matters enormously in coastal areas, low-lying inland areas, and anywhere near rivers or drainage systems. Tampa Bay, Miami, Fort Lauderdale, Jacksonville, Naples, Fort Myers, these areas carry serious and well-documented flood risk that can devastate everything a renter owns. The limitation of this law is that it only requires landlords to disclose what they actually know. They aren't required to hire a flood inspector or conduct an independent investigation into the property's flood history. If they've owned the property for 2 years and it flooded badly under a previous owner, they may simply not know. Don't rely solely on your landlord's disclosure. Before signing any lease in Florida, especially near water or in low-lying areas, check FEMA's Flood Map Service Center yourself. It's a free public tool where you type in the property address and see its flood zone designation. Ask your landlord directly about any flooding history and get their response in writing. Ask neighbors if you can. Check local news archives. Do your own research. Flood insurance is a separate and critical issue. Standard renter's insurance does not cover flood damage under any circumstances. If water rises into your apartment because of a storm surge, a river overflow, or drainage failure, your regular renter's policy will not pay $1 for your destroyed belongings. You need a separate flood insurance policy, and in high-risk zones, those policies can cost between $500 and $2,000 annually. Some landlords now require tenants in designated flood zones to carry flood insurance as a specific lease condition, and that requirement is completely legal. Factor that cost into your budget honestly when you're evaluating whether a property is actually affordable for you. Your rights when landlords don't return your deposit. Florida Statute 8349 is one of the most powerful tools renters have, and landlords violate it constantly, sometimes out of greed, sometimes out of ignorance of the law's precise requirements. When you move out, you must provide your landlord with your new mailing address in writing. Once you do that, the clock starts. If your landlord intends to return your full deposit with no deductions, they have 15 days to send it to you. If they want to make any deductions at all, they have exactly 30 days to send you written notice that explicitly describes what they're charging you for and the dollar amount for each item. After receiving that notice, you have 15 days to object in writing if you disagree with any of the claimed deductions. Here is the enforcement mechanism that most tenants never know about and that most landlords desperately hope you don't discover. If your landlord fails to send you the required written notice within 30 days of your move out, they legally forfeit their right to keep any portion of your deposit, even if you genuinely cause damage. Even if you left the place in terrible condition, if they miss that 30-day deadline, the law requires them to return your full deposit. Large numbers of landlords miss this deadline either because they're disorganized or because they assume tenants don't know the rule. If your landlord keeps your deposit in violation of the law, you can take them to small claims court without hiring an attorney. If you win, the court can order them to pay your court costs and attorney fees in addition to returning whatever deposit amount they wrongfully kept. Before you move out of any rental, document everything with photographs and video. Walk through the entire unit the day you receive your keys and document its initial condition. Walk through again the day you hand the keys back and document its final condition. Clean thoroughly. Leave it in better condition than you found it. Give your landlord no legitimate basis for deductions and then protect yourself with the documentation to prove it. Florida rental laws are stacked against tenants right now, and they keep moving in the same direction. The 10 areas covered in this video represent real changes that have real financial consequences for real people. Consequences that your landlord understands far better than most renters do, because landlords have professional networks, property management companies, and attorneys keeping them informed. Now you know what changed. You know what your rights are. You know what the traps look like before you step into them. Keep your documentation tight, read every lease clause carefully before you sign, and never assume your landlord is presenting you with the only option available. Knowledge is the only real protection renters have in Florida right now. Use it.